I'm Walter Isaacson of the Aspen Institute. I'm with Jeffrey Rosen of the National Constitution Center. We've been talking about the document that sets forth our nation, the Constitution, and now we're on to the Bill of Rights. Let's just start with the First Amendment. Congress shall make no law respecting an establishment of religion. Okay, let's stop there. What does that mean?
Well, the states at the time of the Bill of Rights had established religion, Congregationalism and Unitarianism in Massachusetts and Connecticut and so forth. So at the very least, this clause is designed to prevent Congress from creating a national church that would disestablish the state establishments. So if you want to get a little complicated, it's an anti-disestablishment clause. It's basically saying the reason Congress can't set up a national church, but the reason it can't do that is because the states have to be free to maintain their own established
churches. So in
churches.
other words, the states under the Constitution could establish religion.
Well, at the time of the framing, they could. However, after the Bill of Rights was incorporated against the states, after the passage of the 14th Amendment, states can no longer establish religion either. There are some scholars who think that it was wrong to incorporate the Establishment Clause against the states, and indeed Justice Clarence Thomas has taken that position. He says apparently that the states, if they choose, should be free to set up established religions today.
Wow. And it says, though, that it can't prohibit the free exercise of religion. Does that add something to that?
It sure does. There's a difference between establishing a church, which the Establishment Clause prohibits, and creating exemptions for religiously motivated individuals who want to be free from obeying generally applicable laws. So just recently we had a controversy over whether religiously motivated corporations who don't want to provide contraception coverage under the Affordable Care Act should get an exemption. That case was litigated under the so-called Religious Freedom Restoration Act, but some people also think that to compel these corporations to provide the coverage would have violated their free exercise rights under the First Amendment.
And when did we end up getting what we call separation of church and state?
Well, the metaphor, Thomas Jefferson had used a version of it. George Washington had talked about toleration for the Jews of Newport, but it wasn't until the post-war period that the principle was formally established that in striking down school prayer, the Supreme Court said that states had to respect the separation of church and state, and that was when the First Amendment really got up and running.
And the amendment goes on to say that Congress shall make no law abridging the freedom of speech or of the press or of the right of the people peaceably to assemble. This seems to be the real core of what we were fighting for in our revolution.
If you had to pick out three central words of the Bill of Rights, it would have to be freedom of speech, or make it four, the freedom of speech. Absolutely, the speech of James Otis denouncing the writs of assistance, the other pamphlets filed by the colonists criticizing King George, the Declaration of Independence itself, all were centrally rooted in this idea that freedom of speech was a natural right that came from God and not from government, and that the British system, which was to punish people for seditious libel, in other words, for criticizing the king, was an offense. Under the British system, the truer the libel, the greater the crime. In other words, if you said something bad about the king that was true, then you go to jail for even longer. Madison and Jefferson, in the Virginia and Kentucky resolutions, criticized the Adams administration for trying to criminalize its critics in the so-called Alien and Sedition Acts, which remarkably criminalized speech against the Federalist president, Adams, but not against the Republican vice president, Thomas Jefferson. It wasn't until the 1960s that the Supreme Court formally repudiated seditious libel and said that speech can only be banned if it threatens to cause imminent lawless action. But these, let's call them four words, the freedom of speech, the most litigated, the most cherished.
Give me an example of how we're litigating the freedom of speech today.
It is impossible to think of a topic that's not being litigated as the freedom of speech, from campaign finance reform, where the Supreme Court held that corporations have the same free speech rights as natural persons, to funeral protests, where the Supreme Court said that you can say hateful things in front of funerals, even if they're deeply offensive, to the question of whether abortion protesters can be prohibited from approaching people near a clinic. Most of our most hotly contested questions involve freedom of speech. It's remarkable what a bipartisan agreement there is about the centrality of the First Amendment. There are cases striking down vile and offensive videos that depict offense against animals, for example, or violent restrictions on violent video games. All of these laws have been repudiated by bipartisan majorities of the Supreme Court. Really, the American free speech tradition is the crown jewel of our constitutional tradition. It's the one thing that distinguishes us from Europe, which at this very moment is recognized a broad new right to be forgotten in the European Court of
So in other words,
Justice.
forcing people to take down Google links, which in a way is a real abridgment of a freedom of speech.
According to the American tradition, speech cannot be banned, even if it's offensive, unless it threatens to cause imminent violence. That's a remarkable achievement.
And
in
it's
America.
interesting that, once again, this is something that cuts across liberal and conservative. You can have a Scalia as well as a Ginsburg be very absolutist on freedom of speech at times.
Completely so. The justice who's most passionate about speech is Justice Anthony Kennedy, but it's inspiring to see these 9-0 opinions protecting the speech we hate, as Justice Oliver Wendell Holmes called it, because the justices feel that it's
Yeah, it
central
sort of comes down from that march in Skokie, Illinois once, when the Nazis got to march, and the Supreme Court was very clear that, can't stop that, right?
It's most important to protect the speech of those we hate.
And finally, it says, or of the press right here. Does that give a special status to the press? Is the speech of a journalist more important than that of an ordinary citizen?
Well, some people think that it should have special status, and in fact, Justice John Paul Stevens, in his dissenting opinion in the Citizens United case, said it's appropriate to treat the New York Times, which is a for-profit corporation, differently than Exxon, because the press clause of the First Amendment signals out the press as deserving special constitutional protection.
Isn't that kind of confusing in a day when anybody can be a blogger?
Sure is, and that's why bloggers have been the main opponents of so-called journalist shield laws, because shield laws are based on the idea that you have to distinguish between the professional press and everyone else, and now that everyone with Wi-Fi is a journalist, that's a line that's pretty hard to draw.
Well, once again, it shows how our Constitution remains a living document.
It does indeed, and yet always rooted in the original understanding of the framers.
Thank you, Jeffrey.
Thank you.